Good morning, everyone, and thank you for joining us today. My name is Good morning, everyone, and thank you for joining us today. My name is Mayla Jami, and I'm a trial lawyer and the CEO of ME Law. For those who don't know me or are attending our webinar for the first time, welcome. I am a litigator with a practice that spans everything from complex commercial disputes to personal real estate conflicts. Basically, the deal goes sideways, I get the call. Think of me as the person you hope you never need until you really, really do. Today, we're diving into one of the most stressful and increasingly common legal challenges in Ontario, and that is Ontario real estate, failed closings. Whether you're a buyer, seller, broker, investor, or developer, a failed closing can derail a deal, damage reputation, and lead to costly, time-consuming litigation. Over the past few years, we've seen a dynamic shift in Ontario's real estate market. What was once a feeding frenzy of over-asking offers and waived conditions has now given way to economic pressure, financing instability, and builder-side delays. Mortgage interest rates have surged, appraisals are falling short, and even in resale transactions, we're seeing a rise in builders backing out at the 11th hour. In pre-construction, it is not unusual to see developers miss deadlines or buyers try to sign units without success, or even homes, new builds, all of which can trigger serious legal fallout. According to recent data, the GTA alone has seen a spike in failed new build transactions. Some estimates suggest as many as 1 in 5 pre-construction deals are at risk of falling through before completion. Today, we're going to break it all down, not just from a real estate perspective, but from a legal one. How these deals are structured, what actually causes them to fall apart, who is liable when they do, and most importantly, how you can protect yourself from ending up in court or losing a 6-figure deposit. This isn't just theory. We're going to walk through real cases, discuss court decisions in Ontario, and outline practical strategies that you and your clients can apply immediately. At the end, we'll also open the floor for any short Q&A sessions, so if something comes up during the webinar, make a note of it, and we'll try to cover it live. Grab a coffee, a breakfast bagel, and let's dive in. Now we're going to look at first, before we actually talk about the disputes, we need to understand the foundation, how deals are structured. Every failed closing starts with a signed contract or agreement, but what's inside that agreement and how it's managed often determines how vulnerable the deal is. So let's break it down. First, resale deals, then we'll look at new builds. Okay, in resale transactions, let's say a buyer agrees to purchase a house in Toronto. The process begins with the agreement of purchase and sale, or what we call an APS. This is a typically standard AREA form, but don't let the template fool you. The details inside can make or break a deal. Here's what it usually includes. Deposit, typically 5% due within 24 hours, held in trust by the listing brokerage. Conditions, these allow a buyer to walk away legally if unmet. These conditions typically include financing approval, home inspection, or a review of a status certificate, especially in resale condos. Each condition is time limited, only often 5 to 10 days. If the buyer doesn't waive the condition in writing, the deal automatically falls through. Once these conditions are waived, we enter the danger zone. The deal is now firm. Both parties are contractually bound to close on an agreed date. From that point forward, any withdrawal can lead to forfeiture deposit, legal claims, and litigation. Part of that, you also have a certain time period when a title search can occur. You can also include a holdbacks to ensure that conditions are met, like chattels being in working order. For example, you attended the house or condo that was listed for sale, and when you attended, the dryer, washer, microwave, and dishwasher were working, and now they are not. You might want to include in the beginning when negotiating this contract, this agreement, a condition that 5K is held back. Okay, if the chattels are in working condition or order, then the money held back is given to the seller. Typically, you want to have a time period of when they get to that holdback can go from. For example, from the day of closing till about, from 12 p.m. to about, let's say, 5 p.m., or you can say till the next day. They have that opportunity to see the chattels working. These can be very effective in resale purchases of sale, the APS. It's used to ensure that chattels, like I mentioned, are in working order by acting as a form of security for the purchaser. Holdback provisions allow a portion of the purchase price to be withheld for a specified period, as I mentioned, providing the purchaser leverage to address any breaches of representations and warranties by the vendor. This mechanism really ensures that any defects or issues with the chattels, such as like electrical or mechanical problems, can be rectified. If not, the purchaser may retain part of the holdback as compensation for any breach. It's important that your real estate agent, if you are a purchaser, can advise you on how that would look like, how would the condition look like. It's a safeguard, as I mentioned, and it's a practical tool really for managing any claims that could arise from breaches of contract terms related to the chattels. Okay, if not, you're buying them as is. Resale deals often feel safer, and I put that, and I'm putting that in quotes, but they move quickly and leave very little room for error once firm. Okay, pre-construction, right, are a completely different animal. Okay, the agreements are typically 30 plus pages long, written by builders' lawyers and packed with fine print. Some of the clauses are the same across every new build agreement. The deposit structure and closing timeline are much more complex, and I'm going to break it down for you. Deposit structure, buyers usually pay in stages. Example, $5,000 on signing, then 5% in 30 days, 5% in 90 days, and so on. These can add up to about 15 to 20% over time. You have a cooling off period. In Ontario, new build buyers get a 10-day cooling off period to rescind the agreement. After that, they're locked in. During the cooling off period, it is imperative that you get a lawyer to review your contract. You also take time to review it, and you are made aware of what you are agreeing to and whether you want to consider negotiating some of the terms of the contract. You have a closing timeline, often years away. First comes the interim occupancy, then final closing. Both dates are flexible and can be extended by the builder legally and within reason. You have adjustments and hidden costs that you need to be aware of. Buyers may be responsible for thousands in closing adjustments, developmental charges, utility hookups, HST discrepancies, many of which aren't capped. You need to look at the assignment clause. This allows buyers to assign their units before closing, but only if permitted and subject to the builder approval and fees. You need to also think if you have the capacity to enter in the contract. In Ontario, it is presumed that anyone over the age of 18 has the capacity to enter into a contract or manage their own property. There is also a test for mental capacity. The mental capacity really required for entering into a contract is determined by whether the individual can understand the nature and consequence of the transaction at the time of contracting. And we've had a number of individuals we've represented who actually were not even didn't have the capacity to enter the contract. If there is no mental capacity to enter the contract is voidable, not void. If the individual, as I mentioned, lacks the capacity, provided the other party knew or ought to have known that about the incapacity, the test is not about the mental state in general, but specifically about the ability to comprehend the transaction in question. A voidable contract is a valid agreement that can be legally voided at the option of one of the parties. This means that while the contract is initially considered valid and enforceable, one party has the right to cancel or rescind it due to certain circumstances such as misrepresentation, fraud, undue influence, or lack of capacity. If the party with the right to void the contract chooses not to do so, the contract remains valid and enforceable. Okay, so that's a lot of legal stuff that, I need to include, but we're seeing a lot of that. A 17-year-old signed a contract for a new build. Someone had, another had, incapacity issues, right? So these do come up in litigation. Okay. One of the biggest risks is buyers assume appreciation, but if the market turns and appraisals come in low, they can't get financing and they can't close. Okay, so that is the biggest. Buyers don't see that forthcoming. They really don't have. They see this great thing coming up. They're enticed by marketing materials and all that. They go and they want to put an offer on a new build, but they don't project or they don't sit and think about what this looks to financially down the line. You also can't forget that the Tehran warranty, it does protect new home build buyers, okay, against certain defects, but not failed closing or financing issues. Okay. So while resale, okay, deals are fast moving and condition sensitive, new build deals are slow moving and full of legal landmines. In both cases, deposits are exposed. Timelines matter and conditions must be respected, not just contractually, but practically. Many buyers and even agents underestimate how fragile these agreements can be. In the next section, we'll look at what actually causes deals to fall apart and where the trouble usually begins. Now that we've covered how these deals are structured, let's talk about what causes them to collapse. While every case has its nuisance, there are 5 key failure points we see over and over again in practice, especially here in Ontario. 1. Financing falls through. This is by far the most common cause of failed closings in both resale and pre-construction. A buyer may get pre-approved for a mortgage, but the final approval really depends on several things. 1. The property's appraised value. The buyer's current financial picture, which may change between offer and closing. The lender's risk tolerance in a shifting market. In new builds, buyers may sign years before closing, as I mentioned. By the time the unit is ready, or the house, interest rates have climbed, the unit or the house doesn't appraise, or the buyer's income situation has changed. If the lender pulls out at the last minute, the buyer simply can't close, even if they're legally obligated to do so. In Ontario, this is not usually a valid excuse to walk away. Courts have ruled that financing issues, usually specifically conditioned in the contract, do not release the buyer from liability. Okay? In resale transactions, conditions offer legal escape hatchets, but only if they're properly used. Common problems include missing condition deadline, so you have unmet conditions there is the second area. You have waiving conditions under pressure only to later discover an issue, and there's ambiguous language in the condition itself leading to disputes. In court, if the buyer waived the condition but now claims they can't close because financing didn't come through, they are really on shaky ground. Clear documentation and legal advice as at the condition removal stage are critical. Your agent that you use should be working alongside with you and should be explaining the conditions, and that's who you're using first, unless a lawyer is drafting the agreement. The agent should be working with you and should be able to gather information from you as to, are you prepared to waive this condition, or how long do you need? Like, all this stuff is negotiated, okay, prior to entering into the contract, including, for example, like I said, holdback terms, right? Are you buying the property as is where it is? Like, the seller's selling it even though there's issues with the property, right? You cannot go back and try to refute that because, your agent should have explained that to you, and later your solicitor, what that means, okay? Another thing that we look at is we tend to see that buyer's remorse, or cold feet, okay? This is one more emotional but still common, especially in volatile markets. Sometimes buyers overbid in a bidding war, then regret the price. Read the builder agreement post-signing and panic. Get cold feet before closing due to market conditions or personal reasons. Here's the truth. Once the deal is firm, changing your mind is not a legal defense. Unless the contract includes a clear-out clause or unfulfilled condition, the buyer can be held responsible for losses, including resale losses, if the seller or builder later resells the property at a lower price. Always remember, the seller is selling and the buyer is buying. And if the buyer cannot close due to financial reasons, that is the buyer's issue to deal with. Buyers must be aware that making offers and signing contracts of this nature should not be taken lightly. If you are thinking of purchasing a resale or a new build, you must assess your financial situation, determine in advance where your money will be coming from, and seek advice from a lawyer. And the advice you are given from any professional, whether it's your mortgage broker, your financial advisor, or your real estate agent, and on top of that, the advice you get from a lawyer should be taken into consideration. You got to understand these people are not working against you. They're giving you recommendations and they're telling you what fits your picture. Okay, you might not like some of the stuff they're saying, but that doesn't mean that they're working against you. Okay, in new builds, problems are not always on the buyer's side. Okay, buyers, may fail to complete the house or unit by the extended outside date, breach the agreement by delivering something significantly different unit or house than promised. This means that when I say breach the agreement, I mean they deliver a significantly different unit or house than promised, such as reduced square footage, missing or downgraded finishes, major layout changes, or material deviations from the original specifications. This really can include things like switching hardwood flooring to laminate, removing balconies, altering kitchen layouts, lowering ceiling heights, or even changing the location of windows and structural elements. In new build agreements, these changes are often justified under so-called builder's discretion or minor modification clauses. But if the deviation materially impacts the value or livability of the property, it may amount to a legal breach, especially if not clearly disclosed or consented in advance. However, I know this might be difficult to read, but new builds will have clauses like this. This is related to it's clauses in a condominium new build agreement where it's title changes to condominium, and it's not the title's not there, but this clause right here outlines the rights and obligations of the purchaser and the vendor regarding changes to a condominium during construction. It outlines building compliance code, where it states here the condominium will meet Ontario Building Code standards at the time the building permit is issued. It talks about that the purchaser cannot make claims for higher standards, basically stating that the purchaser cannot claim against the vendor for not meeting higher standards of workmanship or materials than those required by building code. It talks about how the vendor can use this clause to prevent the purchaser from making claims about workmanship or materials in the future. It gives the vendor's right to modify, which means that the vendor can change building specifications, site plans, or materials without the purchaser's consent to comply with legal or architectural requirements. It also gives the vendor the right to substitute materials with those of equal or better quality as determined by the vendor's architect. and it indicates that the vendor is not required to notify the purchaser of these changes. And when you sign this agreement, basically this is also saying that the purchaser agrees to these potential changes and must complete the sale regardless of modifications. Overall, it limits the purchaser's ability to contest changes made by the vendor during construction. So if you haven't paid attention to this clause or a clause similar in your agreement of new build, you can't come around and say that it's the builder's fault. The builder changed everything and basically we want to sue them. Okay. Then you also look at clauses like this. Okay, so this is a clause also in a new build agreement. It's titled the representation and marketing materials. This clause clarifies the limitations on representation and marketing materials related to this condominium purchase. The vendor does not guarantee any information in the brochures, drawings, plans, advertisements, or statements by sales representatives renting the area or other matters. So there's no warranty on marketing materials here. It highlights approximate measurements, so it's talking about dimensions, ceiling heights, and other data and marketing materials are approximate. The purchaser is not buying based on price per square foot. Talks about how there's no refunds for variations, right? So the purchaser cannot claim a refund or price reduction based on the final unit size, configuration, or ceiling height. It also it talks about no warranty or chattels or furnishings. So there's no guarantee regarding the size of the location of chattels or furnishings within the unit. Talks about conceptual marketing materials. Basically, the marketing materials inside drawings are conceptual and subject to change. They do not form part of the agreement or provide any warranty. And it talks about views and distance. Distance and views shown in plans or renderings are approximate and may change during construction. So this is an overall summary of what these clauses are saying, but there's something that you need to pay attention to when you enter these agreements. Of course, they're lengthy agreements, so it's important you read the agreements with a lawyer and you ask the lawyer to interpret the clauses that are in the agreements for you to understand. So overall, this clause limits the purchase reliance on marketing materials and representations and emphasizing that they are not part of the contractual agreement. Okay. Another area that can affect a builder default or delay is if a builder goes bankrupt during construction. Okay, now we've seen a lot of this happening in the Greater Toronto area. This could be an issue, okay? A significant issue. So you must be aware, you must understand, and you must get advice before you enter this contract that what would happen if the builder does go bankrupt during the construction. In these cases, builders may have a claim to rescind the agreement and recover deposits, but it's not automatic, okay? They often need legal help to enforce their rights. The Ontario New Homes Warranty Plans Act, enforced by Tehran, provides some buyer protection, as I mentioned, but mostly for construction defects, not contractual disputes or delays. And not all builders are registered with Tehran, which adds another risk layer, okay? In fact, under Ontario law, any builder or vendor of a new home is required to be registered with Tehran and enrolled in the warranty program before entering into a purchase and sale, purchase agreement, or beginning construction. Okay? If the builder operates without a Tehran registration, they are not only violating the law, but they are also leaving the buyer completely exposed with no access to statutory warranty protections for deposit refunds, delayed closing, or structural issues. Before signing, buyers should also verify the builder's registration status directly on the Tehran website. They should have Tehran documents within the new build agreement. If the builder isn't listed, That's a serious red flag and a reason to walk away or speak to a lawyer immediately. Okay? Now, this one is increasing, so it's assignment failure. This one's increasingly relevant in today's pre-construction market. Many buyers, especially investors, enter deals planning to assign their unit before final closing. This means they plan to sell their contract, not the property itself. But assignment is not always guaranteed. It must be permitted in the agreement. Okay? So, I think you put something here.
Yeah, I did.
It's wrong.
Where?
It shouldn't be leasing. It should be assignment because this is the purchase. And this is restrictions
I
on
put it.
Oh, restrictions. Okay.
I put this type
So,
of
for
here.
example, restrictions on assignment and leasing, as you see in front of you, it's very legally written. Okay. Now, it must be permitted in the agreement, as I mentioned. The terms can be surprisingly restrictive. Assignment clauses in builder agreements like this one is both on assignment and leasing, often include, as I mentioned, a requirement for the builder's written consent, which may be withheld for any reason. Sometimes the builder will say that in some of these assignment clauses, 90% of units need to be sold before they give you consent. There is a non-refundable assignment fee, often ranging from $5,000 to $10,000 or more. Here we can see that they're usually in the beginning of your contract. It will tell you that fee. A clause allowing the builder to approve or reject a new buyer, assignee. Restrictions on marketing or listing the assignment publicly. Example, no MLS or online advertising. A deadline after which assignment is no longer allowed, sometimes only within a specified window before closing. Some agreements may appear to allow assignment but include language that makes it nearly impossible in practice, such as requiring the builder to act as their sole discretion or to charge escalating administrative fees. If assignment rights are important to a buyer, especially an investor, those clauses should be carefully negotiated or reviewed by a lawyer before signing, and you must work work with an agent who has experience dealing with assignments. Okay? Any agents will tell you they do, but they don't. Okay? And they would just tell you could sell it later on. No, you must work with an agent who strictly deals with assignments. Okay? The builder often charges higher fees. Okay? Let's go back here. Market conditions can shift and they may not be no takers, okay, at the buyer's price point. When assignment fails, the original buyer remains on the hook to close, and if they can't, they risk losing the entire deposit plus being sued for damages if the builder resales at a loss. So if you're doing this, if you're thinking of assigning, you're buying investment, you're assigning, do all your homework first. Find an agent that can work with you on this specifically, and how you're going to approach it. Okay, so whether it's financial, emotional, or structure, failed closings usually come down to a gap between what was expected and what can actually be delivered. In the next section, we'll talk about what happens next. What are the legal consequences of walking away from a deal? Who keeps the deposit? And can you actually be sued for backing out? Now, so the deal didn't close. What now? Whether it's a resale or new build, a failed closing doesn't simply go away. There are very real legal, financial, and reputational consequences, some immediate, others long-term. So let's break it down. The deposit, who gets it? In Ontario, deposits are generally held in trust, either by the real estate brokerage in resales or the buyer's lawyer in new builds, and also a buyer's lawyer if the agreement is drafted by a lawyer. But once the deal collapses, the deposit just doesn't disappear. It just doesn't disappear and go back into the buyer's pocket. Here's how it really works. If both parties agree that the buyer defaulted, the seller can often retain the deposit as liquidated damages. But if there's a dispute, the deposit holder can't release the funds without joint consent or a court order. Usually, this means that a lawsuit is often required, sometimes just to determine who gets the deposit, even before discussing further damages. Usually, sometimes it's held in trust and a deal is worked out that there is a mutual release. Typically, in the beginning, if you know you're not going to close, you might want to negotiate a mutual release with giving the builder, either the builder or the builders or the resale seller, the deposit with a little bit more money. You sign a mutual release, everyone goes their separate ways. So all that could be negotiated. Sometimes it doesn't, that fails and you actually have to go to litigation. The deposit is held. A lawsuit is started against the brokerage holding that deposit. That brokerage can, an agreement can be had that the deposit can be released to a lawyer's trust account while everything is getting figured out, okay? Or while you go through the steps of litigation. And negotiating, okay? Negotiating a way out of litigation. In resale deals, we frequently see deposits ranging from $10,000 to $100,000, and in new build, state deposits can total hundreds of thousands of dollars. Okay? How it looks like in a new build, purchaser's default. So these are, you must be aware of how this works. Okay, you must ask your lawyer, to explain this to you literally sentence by sentence. Okay, you also must ask your agent in a new build, in a resale, and the lawyer, if you have some time to get financing. Let's say you have 5 days, you might want to speak to a lawyer about the agreement, and you must ask, they must tell you about, and you must get information about what this looks like. Okay, so this slide is what's typically in a new build agreement. So it talks about buyer's default. So it has clause A and clause B here. And I could tell you in layman terms what this is saying. So this is basically saying if the buyer defaults, the seller can cancel the agreement or suspend the buyer's rights. The buyer loses any money already paid, including deposits and payments for extras. The seller doesn't need to prove any loss to keep the money. The seller can also sue for additional damages. It goes on to say that you're leaving the property. If the agreement is canceled, the buyer must leave the property immediately clean and undamaged. The buyer must sign documents confirming they have no claim to the property. If the buyer doesn't sign, the seller can act on their behalf using a power of attorney. It then talks about late payments here. Okay? And that is right here down here. Late payments incur a 24% annum. So there at the bottom, interest rate compound daily. If the buyer delays moving in or transferring title, they pay $200 per day plus legal fees. That is hefty, right? So think about $200 per day plus legal fees. The buyer pays $250 plus tax for each notice sent by the seller's lawyer about any default. Deposit handling as well. If there's a default, any deposits held in trust are released to the seller and the buyer can't claim them back. So you can see it's very builder protected, right? And it's important that you understand that sometimes these are very generic, so they appear in a lot of different new build contracts, but this is very, very important and you must pay attention to this. So even if the seller later resells at a profit, the court may still award them full deposit, okay? And depending on how the original contract was breached. So if you're going to argue that, you put them on notice, you're going to bring litigation and so forth, it's going to be harder for you, to be frank and honest, it'll be harder for you as a buyer to get around what's clearly written in the contract. So there's a lot of, there are judges and arbitrators and so forth who they will say the contract is black and white. You've had the opportunity to get legal advice, and it would be difficult for you to make an argument against that. A failed closing, okay, often leads to a claim for damages. As I stated, here's a common scenario. So I've outlined a common scenario. A buyer agrees to purchase a resale home for $1.2 million but fails to close. The seller relists and sells months later for $1.05 million due to market decline. The seller sues the original buyer for the $150,000 loss, plus legal fees and carrying costs, on top of also obtaining the deposit, right? That is, this all can be negotiated, but typically that is what typically happens. Obviously, you need a good lawyer to negotiate a good, settlement on your behalf, whether you're a buyer or seller, but typically that's what we're seeing happen in courts as a starting point. So it's not, you can move away from that, but that's a starting point. In Ontario, courts have consistently upheld the seller's right to recover damages, and buyers can't simply walk away citing financial difficulty or market shift as an excuse. In new builds, the builder may resell the unit, as I explained, and still come after the original buyer for the difference, as we're seeing lately in the news, especially if prices have dropped since the original sale. Even personal reasons or mental stress don't usually qualify as a legal excuse. Another area we need to look at is reputational and credit damage. Beyond legal liability, failed closings can affect real estate agents and mortgage brokers whose reputations may take a hit with clients or lenders. Buyers who may face credit consequences if sued.
Mortgage, so just emphasize it. You're doing perfect. Like, this is the best out of everything.
Okay. Buyers who may face credit consequences if sued and a judgment is obtained. Sellers who may use valuable time, holding costs, and market momentum. For professionals involved in the transaction, repeated deal failures can lead to regulatory complaints or disciplinary action. And on top of that, let's say you worked a month on a deal as a real estate agent, you can lose your deposit, your commission, right? So there's a lot of things you need to consider, and it's very much important that you are working closely with the individual you're assisting on signing these contracts. There's a reason why there's real estate agents, and there's a reason why there's mortgage brokers. Lawyers could do all of that if they wanted to, but lawyers have specific roles. So do real estate agents, and so do mortgage brokers. When I do come in contact with a client who's like, I have a real estate agent and I'm in this contract and I need to change things, my number one advice to them is usually you need to speak to the real estate agent. They're the ones that are, put the contract together. If there's something you want to add in there, they're most likely, they should be able to assist you. Okay? The short version, okay? A failed closing can become a multi-layer legal problem. Deposits can be tied up for months. Lawsuits can emerge from both sides. And once the matter reaches court, legal costs can quickly surpass the original dispute. In the next section, we'll talk about legal rights, duties, and remedies, and what Ontario courts actually look at when evaluating these kinds of disputes. Okay? At this point, we know how deals are built, why they fall apart, and what happens when they do. Now let's get into the legal heart of the matter. Who's responsible, what duties they owe, and what remedies the law provides when closings fail. Okay? We'll look at this from 5 angles. The legal duties of real estate agents and mortgage professionals, contractual duties of buyers and sellers, what Ontario courts look at in failed closed litigation, what remedies are available, some common claim types, and defenses that arise in court. Now, real estate agents and mortgage brokers are more than facilitators. They owe both statutory and common law duties. Under Ontario's Trust and Real Estate Services Act and Mortgage Brokers, Lenders, and Administrators Act, professionals must act honestly and with integrity, disclose material facts, example known issues with the property or buyer qualifications, explain risks clearly, especially regarding conditions, financing timelines, and assignment clauses. Negligent misrepresentation or failure to disclose can expose professionals to personal liability and regulatory discipline. For example, if an agent pressures a buyer to waive conditions without ensuring mortgage approval and the buyer later defaults, the agent may be drawn into litigation for failing to act in the buyer's best interest. Okay? Duties and liabilities of buyers and sellers. Both buyers and sellers have strict contractual obligations once a deal becomes firm. Buyers must deliver the deposit as agreed, secure financing if not a condition, close on time and provide the required closing documents and funds. Sellers must deliver clear title, discharge all encumbrances, vacate unless otherwise agreed, cooperate in good faith throughout the process. And there are things with that, for example, if buyers assuming the tenants, all that stuff has to be taken care of. Any deviation, even 1 day late, can be treated as a breach of contract. In Ontario courts, they take a strict view of real estate contract enforcement. Parties cannot rely on informal excuses or good faith alone to avoid liability. Okay? And obviously you'll have your solicitor working with you, so that will be able to, like, if you need more time, that can be negotiated. Do you have to put more money in? Do you have to pay for it on the deposit? Do you have to pay lawyer fees for the opposing for the seller, etc., etc.? What Ontario courts consider in failed closings. When these disputes end up in litigation, Ontario judges look at several factors. Who breached first? The party in breach generally cannot sue unless they've corrected their own default first. Was there a genuine attempt to close? Courts assess whether the party tried to get secure financing, gave notice of issues, or simply disappeared. What timelines and conditions followed exactly. Courts don't take lightly to miss dates. Even by 1 day, time is always of the essence in real estate deals, and this is often, you have that clause in the resale contracts. Did one party act in bad faith? Example, did a seller deliberately make it difficult to close, or a buyer ghosting the seller weeks before closing? Evidence like email chains, document trails, and communications through agents are key in determining the credibility and intention. Now, legal remedies if available. So I'm going to just go through this quickly. The legal toolbox is broad, but here are the common remedies as I explained. You got your forfeiture deposit. A seller may retain the deposit as liquidated damages and may still sue for more, right? You have specific performance. A court may order the buyer and seller to complete the deal, especially unique property cases where money is an inadequate substitute. You have damages. So, for example, if property sells lost due to breach, including price differences, legal fees, and carrying costs, they can claim damages. You have rescission. In rare cases, the contract may be rescinded, which is often termed as cancel. For example, if there was fraud, fraudulent misrepresentation, mutual mistake, then you have mutual obligations, right? The non-breaching party must make reasonable efforts to mitigate losses, such as reselling quickly and fairly. Failing to mitigate can reduce the damages award. Now, a couple examples of real claims and common defenses. Buyer backs out of a $1.4 million sale. Seller resales at 1.2 and sues for $200K differences. Court awards full amount plus cost. The buyer's defense, I can't get financing. The judge, not a valid excuse. The common defenses that should have been raised. The seller breached first. Example, failed to discharge a lien or vacate the property. There were no genuine attempts to mitigate from the seller's side. For example, there's force majeure or frustration of contract. Some of these resale agreements will have these clauses there about that in their agreements, but it's rarely accepted unless truly unforeseeable. And there's misrepresentation. Example, non-disclosure of known defects. These arguments are really highly fact-specific and require real documentary evidence. In short, okay, the law doesn't give much sympathy to parties who simply change their minds or fail to prepare. Courts in Ontario expect real estate agreements to be honored to the letter. In the next section, we'll shift to strategy and talk about how to protect yourself from ever getting to the point in the first place. So far, we've seen how deals fall apart and how the law responds, but let's step back and ask a more useful question. How can you protect yourself or your clients before the deal goes off the rails? Whether you're a buyer, seller, investor, broker, or lawyer, these strategies can really help you stay ahead of the risk. For buyers, the number one rule is this: don't assume pre-approval equals guaranteed funds. Get firm financing commitments before waiving conditions. If buying pre-construction, plan for rate increase or appraisal gaps. Work with mortgage broker who understands builder timelines. Work with the mortgage broker who understands builder timelines and assignment risks. Many failed closings happen because buyers waive financing too soon or ignore the fine print in their mortgage approval. If your financial picture changes, your lender's commitment can vanish overnight. Okay? Understand every clause before you sign, whether it's a resale or a 40-page builder agreement. Make sure the client or you actually understand what you're signing. In resale, review conditions, timelines, and obligations. In new builds, get legal review before the 10-day cooling off ends. Don't nit and pick certain clauses in the agreement and ask the lawyer to give you information of those clauses. You need to get the entire agreement. You need to understand it, all of it in its entirety. Watch for hidden builder charges, assignment restrictions, and cap limits. Don't rely on assumptions or verbal explanations. Many disputes come down to what's written, not what is said. Okay? Document everything. In every real estate deal, assume you may end up in court one day. That means keep records of communications, confirm verbal agreements in writing, store all condition waivers, status certificates, financing letters, and notice of extension. In litigation, who has the better paper trail usually wins. Ontario courts play high weight on documentation and email exchange in the time of the deal, not after. At the end of the day, facts matter. Okay? So that's another thing the court looks at. Use real conditions, not cosmetic ones. Avoid using vague or half-hearted conditions just to buy time. If you include a financing or inspection clause, use it seriously. Attach a real deadline. Include the right to terminate. Include, like I said, holdbacks. Use wordings that give legal protection, not just negotiation leverage. Sloppy or cosmetic conditions can backfire in court. Worse, they may not protect you at all because of how they're written. So get legal advice before trouble starts. Too many parties only call a lawyer after the deal collapses. Instead, consult legal counsel during the drafting, review, or condition waiver stage. If you sense risk, delayed financing, developer silence, buyer hesitation, get proactive legal advice. A 30-minute call early on can prevent a 2-year lawsuit later. Think about why you're entering this agreement. Okay, think about why you're doing this. Really think about it, right? Real estate deals move fast, especially in Ontario, high-pressure market, but rushing through them without legal and financial clarity is what leads to litigation. I just want to look at what actually happens in real cases and how different choices could have changed the outcome. Let's make this real, okay? We've talked about law, structure, and strategy, but nothing hits home like actual examples. Here are 3 simplified anonymized stories from real Ontario cases we've seen or followed closely. Each highlights a different risk point and, more importantly, what could have been done differently. A couple buys a pre-construction condo in the GTA for $850,000 in 2021. They put down $170,000 in deposits. Fast forward to 2024, interest rates have doubled and final appraisals comes in at $780,000. Their lender will only finance 80% of the appraised value. The couple can't make out the difference and walks away. The result, the builder resells for $765,000. The original buyers lose their $170,000 deposits and are sued for $85,000 losses. They also pay the builder's legal fees. This outcome was possible because the builder's agreement included a strong default clause, which clearly stated that if the buyer failed to close, the builder can retain all deposit payments and sue for any additional damages, including resale losses, carrying costs, and legal fees. These default clauses are standard in normal builder agreements and heavily favor the vendor. The builders, right? Buyers often sign them without realizing just how exposed they are if they can't close. Now, what went wrong? There was no legal review on the builder's agreement before signing, no backup financing strategy, no assignment clause negotiated. What could have helped? Capping closing adjustments, early legal advice before firming up, and assignment flexibility. Okay? Case number 2, the last minute back out on resale. The situation, a buyer purchased a detached home in Oakville for $1.4 million with a 5% deposit and no conditions. 3 weeks before closing, they panic, Media headlines say the market is crashing. They try to renegotiate, and when the seller refuses, simply refuse to close. The result: the seller relists and sells 2 months later for $1.2 million. The court orders the original buyer to forfeit their $70,000 deposit and pay an additional $130,000 in damage, plus interest and legal costs. So you're paying legal costs to the other lawyer, and you're paying legal costs for your lawyer, okay? What went wrong? No financing condition included, emotional decision without legal consultation, failed to formally notify or negotiate before default. What could have helped? Legal advice as soon as second thoughts arose, proof of good faith effort to close, understanding the real estate contracts in Ontario are strictly enforced. Case study. The agent under fire. A mortgage broker encourages a buyer to waive their financing condition before a commitment was confirmed. The buyer defaults when financing fails and is sued. They turn around and sue the broker for negligence. The result: the court finds the broker acted carelessly in pressuring the buyer to firm up the deal without a valid approval. Damages were split, and the broker's license came under regulatory review. What went wrong? Breach of duty of care on the broker. It was negligence. No documentation. Again, if you're going to find whether the person committed negligence or not, you're going to have to get an expert report, and that in itself is costly, right? It's a cost. It depends on if your facts are significant. The cost of that could be very, very high. No documentation of client's informed consent, overstepping professional boundaries. What could have helped? Clear written communication about the risks, okay? For professional boundaries and full disclosure, documentation of the client's decision and understanding. Each of these outcomes could have been avoided with better communications, earlier legal intervention, and clear contract terms and understanding of the contract. In our final section, we'll open the floor to your questions and tackle what the most relevant to you or your clients. Before we jump into our questions, I want to leave you with this, okay? At Emily Law, we don't just step in after the damage is done. Okay, we work with buyers, sellers, brokers, and developers at every stage, from reviewing agreements before they signed to representing clients in high-stakes litigation when closings go wrong. If you're currently involved in a transaction, if a deal feels unstable, or if you're advising a client who's nervous about what's next, now's the time to talk to a lawyer. We offer strategic consultations, contract reviews, and litigation support focused on protecting your investment, your time, and your peace of mind. You can reach out to us directly, so screenshot this right now. Our contact information, we have a QR code for 10% consultation discounts.
This was question to you.
Yeah, we can. QR code, which will send all attendees today, which will give you 10% off on consultation discount. Now let's open the floor to your questions. Thank you for joining us today.
It was perfect. A little bit more, like 5 minutes more.
It's okay.
It's okay.
I was kind of rushing through in the end, but I think it's okay.
It was ideal.
Yeah.
Like it was best. If you're gonna do like this tomorrow, you're gonna have some clients. And also, like, so I'm putting this QR code, right?
Yeah.
For discount. Okay.
Yeah.
So just let me fix presentation and we can try like.
Yeah.
When you have time. Now or later? I don't think it should be actually QR. I'm gonna update
Yeah.
promo code or something.
this again in a few minutes?
Yeah, because I need to create this promo code because I want to indicate that it is only for new clients, not for existing. Yeah, 10% consultation, 10% discount for initial consultation only for new clients.
Yeah. little bit more practice will be fine. What are you eating?
It's just sausage.
Sausage?
Yeah, I love them.
Or like beef? Is it beef?
Yeah. You're eating constantly or something like this. Deposit. I'm thinking, what kind of promo code? How we should call it? Like deposit 25 or?
No.
Webinar. I'm doing it valid only to July 1st.
Yeah.
Webinar. Yeah. I need 2 more minutes probably. Place it. Or we can start practicing now. and I'm going to do it later.
Just give me,
If you
can we
have
just,
time.
it's okay, do it now for a
Okay.
sec, I'm just checking
Okay.
some.
Mhm.
Oh my god, this thing smells good. When you ate it down.
I'm going for it. Are you ready? I'm going to finish with promo code after because I need to create a page on our website. If you want to look at it, look like this. Like this.
Let's plug in my phone. My laptop is okay for now.
Just give me a second.
It's okay. How long do you need?
I just print like because I updated some parts.
Okay, I'm gonna step out and come back then, okay?
Yeah,
I left
yeah.
my phone here.
You can take it or
No, I don't need it right now.
I'll
Okay?
Okay. Just 5 minutes max.
5-10 minutes.
Yeah.
I'll be back.
Yeah. Okay.
Yeah.
Cost assessment probably.
Oh, right.
Really you too. We already got everything. Hmm?
You already got everything
The invoice is specific.
good. Oh, okay.
May 26th was Monday, right? Yeah. He put it on May 26th. So he sent me the email Sunday night. And this is entry May 26th. So didn't she give us the original?
What's this? Service?
It says it's ordered that pursuant to section 616 Act the said solicitors deliver to the applicant charges of dispersants of the documents when it sells the disorder.
So we send all the bills.
Yeah.
So do we need to actually serve it or we just can send it?
Deliver.
So we're sending him the
And
report,
that the same,
disengagement letter.
I already did, and that the same.
No, she
I
said.
got it by registered mail.
By registered. Can we include all the bills there as well?
Yeah.
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 So let's just.
And the same and delivered be referred to the assessment officer.
Yeah. So and then I guess and the same when delivered be referred to system. So how to be referred? We have to.
Maybe these are the ones that
Send.
delivered to him, and then he refers us to the assessment officer. But this is so funny. He messaged me Sunday. Remember he emailed me Sunday night? No, not Sunday, Monday, right? Yesterday was the 26th, right?
Yeah.
We wouldn't have this done yesterday.
No, yesterday was 27th. Tuesday.
So can we just if we need to send it to him by registered mail,
Yes, well, I am sending registered mail. That's why I asked
maybe
you.
we can even include the this copy of this, put it there. So we put this engagement letter, we put the order,
That's why I asked you
put
to
all the invoices and
He
those
just delivered, that was just a letter to us, and
I'll do it myself.
I think so too, yeah.
Can
Just come in here.
Just, I gotta make sure, we do it right. So
Yeah, like there's no signature.
send one to the assistant
That's
office?
what it says.
How do we send it? Can we send it via email? I think so. We gotta find out.
Same time or delivery.
It doesn't have it. Yeah, just call. Yeah. Yeah. Yeah, but we're not consenting that all the invoices. We're not consenting to that. Yeah, but we're not agreeing that he gets to assess all of them.
No, you can't. It's only the. Yeah, so it's only the last one. Only the last one. Okay. The other ones are over.
We already sent them, yeah, but shouldn't we write a letter basically saying that like the other invoices are past 3 days?
He already has access to all the invoices.
Yeah.
And then the other ones out.
Yeah.
It doesn't go there.
No.
Oh. So yeah. I guess, because how is it, who determines,
We're not agreeing that he says all of our invoices.
and we don't have to be an application, but who's supposed to, like, a lawyer tells him, like, are we supposed to tell him that you're only giving this one because, or should we just send him only one?
No, but we should write in a letter that pursuant to the Citizens Act, we only entitled to request assistance for 3 days. Invoices that we give to 3 days.
Yeah, so that'll be the April, June,
Yeah.
if this was even on the 29th, that's okay.
Yeah. Hold on. Hold on. Let's get the numbers.
They postponed the vote. So this is only, this is April 22nd, which is over 30 days. This is in the amount of $8,700.
Okay. Hold on. So we just got this served to us from Alex.
Yeah. That's it.
I don't think we need to send him all the invoices because we're not consenting that he assesses all of the accounts. So should we, write a letter, no?
So, is order, okay. Section 6.1. think you got the wrong section. Because this was for the delivery of the accounts. We've already delivered the accounts.
Yeah.
Yeah, it says where a client or other person obtains in order for